it's Ron. We've got a little bit shorter lesson today. It's also a little bit tardy, but I did want to give you something this week. One of my subscribers actually noticed and made it clear to me that he noticed that I hadn't posted. So I told him I'd get something up this weekend. At the end of the last lesson, we talked about service of process or joining issue. In other words, the defendant has now been properly served with the complaint and has 20 or 30 days or so, depending on the jurisdiction and depending on perhaps other factors. But typically 20 to 30 days. In federal court, it's 20 days to respond. What does respond mean? Respond means to either file an answer or to file a motion. And today, I just in this abbreviated episode or this abbreviated lesson, want to talk about the difference between those two things. An answer says, okay, you do seem to have some kind of claim, and if it were true, I would have to defend against it. Therefore, I deny allegations X, Y, and Z. There are two things you do in an answer, and I'm going to talk about them in much more detail in a later lesson. But basically, you respond with denials or admissions of the particular allegations against you as the defendant. And there's actually another option, which is you can deny on the ground that you don't know. You have no way of knowing the answer. Maybe it's an allegation about what someone other than you thought or did or said, and you have no way of knowing. So that is called denying information, denying on the ground that you don't have knowledge or information that would enable you to answer, which amounts to a denial, but which is different from a denial, right? Because your denial says it didn't happen. Denying on the ground of information or belief means, I don't know. You can also, in your answer, assert what are called affirmative defenses, and we'll talk about those in more detail. The other option for a defendant who has to file some kind of response by a deadline, typically in the range of 20 to 30 days after being served with a complaint, is to make a motion. A motion to dismiss on a number of grounds, or a motion to transfer the case to another court or another venue on any number of grounds. And this is a very important juncture in the lawsuit, because what it's saying is, even if everything you said were true, you wouldn't have a case. You wouldn't have a case, or you wouldn't have the right to litigate this case in this court at this time. That might be because a statute of limitations has lapsed and you're not entitled to proceed with this case. It may be because you're basing your claim on a legal theory that does not provide the relief you claim it does. Many, many reasons. I'm going to go through them in detail, and it's important that we do so, because a lot of the cases you read about in the news, a lot of the decisions by judges that you read about, are at this stage where a defendant makes a motion to dismiss and a court rules on it. So before there's been any discovery, before there's been any testimony, any documents exchanged, any substantive rulings on the merits of the case based on the evidence, a judge will often have the first say as to whether or not this is even a lawsuit that's worth, in his or her opinion, bothering the judiciary with. It's a very, very loaded and very current events-wise, very significant part of the civil litigation process. So that's my introduction to this next section, which is responding to complaints, which, as I will explain to you in some detail later, I have a little bit of special experience teaching about. We'll talk about that later, and I thank you for your patience and for subscribing.